Welcome back, everyone, to our Arthashastra series. This is the 8th deep dive, and today we're jumping into part 8.
That's right, law and justice. And forget dry history, we're talking about a surprisingly sophisticated system. Governance, social rules. You'll see some maybe striking parallels and some really fascinating differences to modern life.
Absolutely. The nuances are quite something.
Yeah, so we'll be looking at excerpts discussing, well, everything from labor, including some unexpected angles on unfree labor, actually.
That's a big one.
Right, to intricate family law, the penal system, civil suits, contracts, property rights, sexual offenses, and even the ethical ideas behind their whole concept of justice.
The philosophical underpinnings, yeah.
Okay, let's jump right in. Labor in ancient India, and maybe something that challenges assumptions right off the bat.
Indeed. It's quite interesting because when you look at, say, accounts from figures like Megasthenes and Arrian.
These observers, right.
Exactly. They described Indians as all free, which, suggests a big difference from the kind of widespread chattel slavery we often associate with ancient Greece.
Okay.
But when we delve into Kautilya's texts, the Arthashastra particularly, we find a really detailed classification of unfree labor.
Ah, so it wasn't a simple yes-no on slavery, it's more nuanced.
Precisely. It seems to be less about a binary, slave or free, and more about understanding the specific forms of unfree labor that existed.
Right.
Kautilya uses terms like dasa, dasattva, and dasabhava. Now, these clearly mean a lack of personal freedom, significant restrictions.
Okay.
But the framework suggests a system that, while definitely restrictive, might have been seen perhaps as less exploitative than chattel slavery elsewhere. What's striking is that even within these restrictive systems, there seem to be attempts to limit exploitation.
Okay, so break it down for us. What different kinds of unfree labor are we actually talking about here?
Well, Kautilya lays out several categories. Dasabhava seems the closest to what we might think of as traditional slavery, the most unfree state.
The bottom rung, essentially.
Pretty much. Then there's Uttarasattva, which describes someone working basically just for their upkeep, maybe because of famine or something like that.
Survival labor?
Kinda, yeah. And importantly, there's Ahitaka. This refers to bonded labor, someone pledged to work off a debt, or maybe a ransom.
Right. Think of ahitaka, this bonded labor, as a system where someone's work was collateral for a debt. Almost like taking out a loan today, but, well, your body is the guarantee.
That's a good way to put it. It's debt bondage.
Bonded labor. Gosh, a concept that unfortunately still exists in various forms today. How did it work back then?
Well, it involves someone being pledged, either themselves or by someone else, or being forced to work because of debt, distress, even capture in war.
Captured in war, okay.
And the rules around getting out of it, redemption, were quite specific. You could pay off the debt or the ransom amount.
Straightforward enough.
For war captives, it was that, or they could work off the debt labor equivalent to, I think, twice the ransom value.
Twice the ransom. Okay.
Yeah.
Interesting. And did these bonded laborers have any rights? Any protections at all?
Yes, and this is where it gets really interesting and maybe surprising. Children born to an Arya, generally meaning someone within the Hindu social structure, the Varna system, who had self-mortgaged.
So pledged themselves.
Right. Their children were considered free. It's important to note, though, that legal protections often differed based on this social identity, this Varna. It highlights the hierarchical nature of the society.
That's a key point. Hierarchy matters.
Always. But these self-mortgaged Aryas also had the right to keep any earnings they made beyond their keep, and they could inherit paternal property.
Wow. Okay.
And there were even rules against making them do certain degrading tasks, handling dung, corpses, things like that.
So some dignity was preserved in theory.
It seems so. And women workers had specific protections against mistreatment. Sexual abuse by a master had serious consequences.
Like,
The master forfeited the debt entirely. Gone. And they could face fines on top of that.
that's actually quite a significant level of protection for the time, isn't it?
It really is, yeah.
But what were their obligations? Could they just walk away? Were they essentially trapped?
No, they weren't permitted to run away. Trying to escape twice could mean forfeiting their right to redemption altogether.
Ah, okay. High stakes.
And if someone who was pledged by another person tried to escape, especially the idea of leaving the country, they also faced penalties. So the system, it seems, tried to balance the creditor's rights with some protections for the laborer while, still keeping social order.
Right, maintaining control. Okay, so bonded labor is one form. What about the dasa, the slaves themselves?
Kautilya categorizes them in 4 main ways. those born into the household.
Born a slave.
Inherited slaves, purchased slaves, and those acquired through other means like capture or maybe as gifts.
Okay.
And interestingly, there was apparently a 1-year period where you could revoke a contract of sale or purchase of a slave.
A cooling off period. Why would they do that?
Well, the text doesn't explicitly say why, but you could speculate, right? Maybe issues with the slave's health or skills weren't as advertised, maybe temperament. It adds a layer of contractual complexity.
Fascinating. And were there also protections for slaves? Especially vulnerable ones, like children and women?
Absolutely. Children under 8 years old were not supposed to be made to work, especially not menial jobs or being sent abroad.
That seems quite progressive.
And pregnant slaves had significant protections. They couldn't be sold or mortgaged without ensuring their welfare. Causing an abortion was punishable.
Okay.
And here's a really striking provision. If a slave woman bore her master's child,
Yes.
both the mother and the child were granted their freedom automatically.
Really? That's huge. What about abuse?
Rape or abuse of slaves also led to the master forfeiting the debt if it was a debt slave situation and potentially facing fines. This focus on the welfare of even the most vulnerable, it suggests a societal value placed on perhaps protecting life, even in that context.
It sounds like while, okay, slavery existed, it was far from an entirely unchecked, brutal system like maybe we imagine sometimes.
It appears more regulated, yes, more nuanced.
What about free laborers, then? How are they treated?
Kautilya distinguishes between karmakara, who were like casual laborers, day workers maybe,
Got it.
and brithaka, who were employed under a contract. Agreements for casual labor were supposed to be public, with wages agreed upon upfront.
Public agreements. Interesting.
Yeah, and there were customary rates for different kinds of work, cultivators, cowherds, merchants, etc. If there was a dispute over wages, it was meant to be settled by witnesses.
And if the employer didn't pay?
Failure to pay agreed wages was punishable. So there was a framework there intended to ensure, fair compensation for work done.
A system for fair pay, at least in principle. What about the rights of these employees?
Well, employees had the right to end a contract if they got sick or became incapable of working, or if the work itself was considered unseemly or inappropriate.
Okay, an out clause.
But conversely, they were obligated to perform their duties as agreed. If they didn't, they could face fines. Employers, in turn, could reject substandard work and penalize the worker accordingly.
So, mutual obligations.
It seems like a reciprocal arrangement, yeah, outlining what both sides owed each other.
And what if people work together, like in guilds or teams?
The rules for collective labor, like guilds, pretty much mirrored those for individual workers. Similar rights, similar obligations.
Makes sense.
Importantly, members couldn't just abandon the work without telling the employer, and earnings were supposed to be shared equally, or, however they'd agreed beforehand.
Right.
It really paints a picture of a system designed to regulate many different forms of labor and ensure at least some level of fairness, even within what was clearly a hierarchical society.
Okay, let's shift gears now. Family law. This sounds like it could be a whole other deep dive on its own.
Oh, it absolutely could. It was a really complex and highly regulated area.
So what were some key aspects? Let's start with, say, marriage and divorce. Remarriage for women.
Right. The conditions for a woman remarrying depended heavily on a few things. First, had the marriage actually been consummated?
Okay.
And second, what were the circumstances of the husband's absence, if he was absent? Before consummation, if the husband was gone, the wife had to wait a specific period.
How long?
It varied. It depended on whether they had communication, if he was providing financial support. Different factors changed the waiting time before she could legally remarry.
Okay, that's before consummation. What about after?
If the marriage was consummated and the husband had been gone for a very long time, or maybe he'd become an ascetic, renounced the world,
Right.
then the waiting periods were longer. Typically 7 menstrual cycles if there were no children, or a full year if children were present.
And could she just marry anyone?
Interestingly, no. Remarriage was often expected, or perhaps preferred, to be within the husband's family, his brothers, other relatives, following a specific order of priority.
Livery marriage, essentially.
Yes, shades of that. And there were even special rules for Brahmin wives and wives of royal servants, again showing how social status impacted the law.
Always back to status. What about the really difficult issue of adultery? How was that handled?
Adultery was treated with extreme seriousness, utmost seriousness.
I can imagine.
If a wife was found guilty while her husband was away, her lover could face the death penalty.
Death.
And she herself could face mutilation, cutting off the nose or ears, perhaps, unless her husband chose to forgive her.
Forgiveness was an option then.
It seems so, from the husband.
That's it.
But concealing adultery was also a punishable offense. Well, it's hard for us to comprehend such severe penalties today.
Yeah, it really is. Makes you wonder if it was purely about deterrence, or were there other social, maybe religious factors driving that severity?
That's a great question. Probably a mix of all those things. Property rights, lineage purity, social order, religious ideas about fidelity.
Okay, so that's the wife's side. What about the man's obligations? Could he just pack up and leave?
Well, if a man chose to renounce household life, become an ascetic,
Yes.
he had a clear responsibility to ensure his wife and children were provided for. He couldn't just leave them destitute.
Yeah.
That suggests a recognition, at least, of the economic vulnerability of women and children in that society.
Some level of protection there. And divorce, was that even a thing in ancient India?
It really depended on the type of marriage. The texts mention 8 different forms.
My goodness.
Yeah, ranging from the more religiously approved forms like the Brahma marriage, down to things involving capture or deception like Rakshasa or Paisasha marriages.
Okay, quite a range.
In the first 4 types, considered the more proper or sacred ones, divorce generally wasn't permitted, not an option.
And the other types.
In the others, divorce could happen, but usually only if there was proven mutual hatred between the spouses. And the party seeking the divorce typically had to return any gifts they'd received from the other.
So, not easy even then.
Not easy. And even if they separated, the husband often still had an obligation to provide maintenance for his wife under specific conditions laid out in the law.
Maintenance or alimony. Okay. Now, inheritance. Who got the family property when someone died?
Sons were generally the primary heirs,
Why sons mainly?
largely because they had the responsibility for performing essential religious rituals for the ancestors. That was crucial. The eldest son often held a special position, maybe a larger share or specific duties.
What if there were no sons?
Then property could pass to daughters, or even the deceased father.
Daughters could inherit them.
Yes, in the absence of sons. And if a man had multiple wives from different social strata, different varnas...
Polygamy, right?
Exactly. The inheritance rights of the sons were actually determined by their mother's social status.
So hierarchy within the heirs, too.
Absolutely. There were even rules about extra shares for the eldest son, but exceptions could be made if he misbehaved badly. So it seems their inheritance system was heavily focused on maintaining the lineage, the family unit, with very clear hierarchies and specific roles for everyone.
What about daughters generally? Did they get anything if there were sons?
Their property rights seem to have been generally limited to more personal items, household things like utensils, ornaments, their stridhana or woman's wealth.
Okay.
However, there's a hint that even disinherited individuals, maybe outcasts or those with certain disabilities, might have some provision made so their wives and non-disabled children could still inherit something. It suggests some level of social consideration maybe for those on the margins.
That's interesting. We also saw this term niyoga or levirate. What was that exactly?
Ah, yes. This was a practice where if a man died without any heirs, his wife could, under specific rules and with family consent, bear a son with a close relative, usually his brother.
To continue the family line.
Precisely. It was about lineage continuation. And sons born from these Niyogi unions had defined inheritance rights.
Complex stuff.
Very. And just to underscore how important family wealth was, misappropriating it, like stealing from the family pot, was punishable by a pretty hefty fine, 100 panas, I think the text says.
Okay. Now, those 8 types of marriage you mentioned, that sounds involved. Were they just different levels of social acceptance, or did they have distinct legal consequences?
Oh, they definitely had different levels of social acceptance, yes. But crucially, they also had different legal implications, particularly around whether divorce was possible and the inheritance rights of children born from those unions.
So the type of marriage really mattered legally.
Hugely. They reflected a whole range of societal norms, maybe different regional customs, perhaps even older historical practices that got codified.
And what about dowry and gifts around marriage? Who owned that stuff?
Initially, the dowry seems to have belonged to the woman's parents. If she remarried later, she would receive a new dowry for that marriage. Gifts from the groom to the bride were encouraged.
Yeah.
And interestingly, marriage contracts could actually be revoked before consummation, at least in the higher social groups, if significant sexual defects were discovered in either party.
Wow, really?
Yes, and deception about such things was punishable. It suggests a real concern for the well, the physical and perhaps reproductive viability of the marriage.
It sounds like women did have some agency in marriage, though. You mentioned the right to marry after a certain age.
Yes, that's right. A daughter apparently had the right to arrange her own marriage if, 3 years after reaching puberty, her father had neglected his duty to find her a suitable spouse.
She could choose her own husband then.
In that specific circumstance, yes. The texts also touch on things like the expected ages for consummation, the expectation of the bride's virginity with penalties if she wasn't a virgin and hadn't disclosed it,
Okay.
and also conjugal duties, including, significantly, a prohibition against forced intercourse if wife was unwilling. Plus, the husband's responsibilities for her general well-being, emotional and physical needs.
That prohibition on forced intercourse seems noteworthy.
It certainly stands out, yes.
And finally, just wrapping up family law, what happened to a wife's property or inheritance if her husband died?
Okay, so wives had rights to their stridhana, that's the property they brought into the marriage, or received as gifts.
Her personal wealth?
Exactly. Widows who didn't remarry generally retained their inheritance from their husband, which would then typically pass to their sons after her death.
But what if she did remarry?
If a widow remarried, she often forfeited her inheritance rights from her first husband's estate.
Okay, that makes a kind of sense.
And remember, polygamy was practiced, but the texts stress that men had obligations to all their wives. If he took a new wife who displaced an existing one, compensation was due to the displaced wife.
Some protection there, too.
Yes. Marital breakdown was also addressed conditions under which a wife could legally leave her husband, punishments for abuse by the husband, but also penalties for a wife who seriously neglected her duties.
Balanced in a way.
In a way, even a wife traveling with someone who wasn't a family member could raise suspicions or have legal implications regarding adultery. It's clear there was this incredibly detailed, though often, yes, hierarchical framework governing almost every aspect of family life.
Okay, wow. This is giving us such a fascinating, intricate picture of ancient Indian society. Let's move on now to the penal system. The punishments. What were the big goals of Dandaniti, the science of punishment?
Right, Dandaniti. The main aims were pretty clear.
Yeah.
Maintain social order, protect the interests of the state, and prevent dissent or rebellion.
Keep things running smoothly and keep the king in power.
Essentially, yes.
Yeah.
But the underlying principles guiding it were quite significant for the time.
Like what? What principles are we talking about?
Well, first, the rule of law itself was seen as the absolute foundation of security and public welfare. Justice was meant to be impartial. The law should apply equally, with no distinction between, say, a royal family member and a commoner.
Really? No special treatment for royals?
That was the principle, yes. How perfectly it was applied in practice is another question, but the ideal was impartiality.
Okay.
Proportionality.
Yeah.
Punishments were supposed to fit the crime, neither too lenient, which could lead to contempt for the law, nor too harsh, which could cause unrest.
Finding the right balance.
Exactly. And leniency was advised for specific groups or circumstances: pilgrims, the sick, people acting out of ignorance or under duress. This suggests a degree of consideration for individual context.
That seems quite reasonable. What about repeat offenders? Did they get tougher sentences?
Oh, absolutely. The severity of punishment escalated sharply for repeat offenses. Double the penalty for the second time, triple for the third. And for a fourth offense of the same kind, it was often left to the king's discretion, which could mean very severe punishment.
Okay. A clear deterrent.
And interestingly, if an innocent person was punished unjustly, the fault was seen to lie with the king himself. He was expected to perform atonement, make amends.
The king was accountable for miscarriages of justice.
Yes. This emphasis on the king's personal responsibility for unjust punishment is a fascinating early example of, the concept of state responsibility.
That's a really strong sense of responsibility at the top. What kind of punishments were actually common?
Fines and monetary compensation were widely used, often based on local or regional customs. For some crimes that might otherwise involve physical punishment, like mutilation, fines could sometimes be substituted.
Paying your way out of physical punishment.
In some cases, yes. However, for serious crimes, theft, defamation, assault, abduction, the texts are clear that prescribed punishments beyond just penance or compensation were required.
Okay. And what were some of these more severe prescribed punishments?
Well, mutilation or amputation was definitely used for certain crimes, though, as we said, fines were sometimes an alternative.
Gruesome.
And capital punishment was reserved for the most severe crimes, like murder or rape. The methods could be brutal impaling or even being gored to death by an elephant.
Gored by an elephant.
Yes, and that seems to have had almost ritualistic aspects to it sometimes. There are also very strict rules about how the bodies of executed criminals were disposed of. Unauthorized removal or cremation carried penalties.
Wow. What about Brahmins, the priestly class? Were they exempt?
Not exempt, no. But their punishments were often different. Instead of execution or mutilation for certain crimes, they might be branded with specific marks indicating the nature of their offense. A dog for theft, a headless trunk for murder, etc.
Symbolic punishment.
Symbolic and shaming, yes, followed by exile, or sometimes forced labor in the mines. Even things like witchcraft and harmful magic were generally punishable. Though interestingly, there seem to be exceptions for maybe love spells within marriage or courtship.
A little leeway for romance magic?
Apparently so. And just to ensure fairness in the system, adding extra surcharges onto official fines was explicitly forbidden.
No hiddy fees on your punishment.
Exactly. And on the flip side, it wasn't all punishment. Good public officials, those who did their jobs well and justly, were supposed to be recognized and rewarded.
Okay. It sounds like a system that really tried to balance deterrence, maybe even terror for some crimes, with a degree of fairness and structure even within that strict hierarchy.
That seems to be the aim, yes.
Let's move on to how they handled disagreements between people's civil suits. What was the framework for those disputes?
The framework there really emphasized fairness and clarity. One really notable aspect was this idea of judicial cognizance.
What does that mean?
It means a judge could proactively step in and represent the interests of someone who might be vulnerable or unable to represent themselves effectively in court.
Like who?
Like, say, deities, meaning temple property, Brahmins, ascetics, women, minors, the elderly, the sick, anyone considered helpless. The judge could take up their case even if they didn't formally bring it themselves.
That's a really interesting idea, ensuring access to justice for potentially marginalized people.
Exactly. It aimed to prevent them from being disadvantaged just because they couldn't navigate the system.
What about legal technicalities? Could a powerful person get a case thrown out on a loophole if it involved one of these vulnerable individuals?
Kautilya's system seemed designed to prevent that. It explicitly states that suits involving these vulnerable individuals should not be dismissed just because of issues with jurisdiction or time limits passing or rules about adverse possession.
Substance over form.
Very much so in those cases. It highlights a focus on achieving actual justice rather than getting bogged down in procedural traps.
Okay, so who could actually bring a case and who could be sued?
Both the plaintiff, the person bringing the suit, and the defendant needed to have proper legal standing. The system also involves sureties people, guaranteeing that the parties would show up and comply with the judgment.
Like posting bail or bond.
Something like that, yeah. It suggests a financial safeguard to make sure fines or damages could actually be paid if someone lost. And crucially, every civil case was meant to be formally recorded.
Written records.
Yes, detailing who the parties were, what the dispute was about, the claims made, the defenses offered, everything written down, ensuring transparency and accountability.
What was the process like once a case was actually in court?
Well, there were rules to keep things moving. The plaintiff had to file their response, their rejoinder, to the defendant's statement pretty promptly. Delays could bring penalties.
Okay.
The defendant then was granted a reasonable time to prepare their defense, maybe 3 to 7 days, up to a maximum around 45 days, the text suggests. But if they failed to present a defense within that time, a decree could be issued against them.
So deadlines mattered.
They did. Efficiency seems to have been a concern.
And what about evidence? That's key in any legal system. How did they figure out who was telling the truth?
Witnesses and evidence were absolutely central. Certain people were excluded from being witnesses if they had a clear conflict of interest. Family members in some cases, enemies, etc.
Makes sense.
But generally, a broad range of witnesses was allowed in many types of cases, like assault, theft, adultery. Interestingly, in secret transactions, where maybe there weren't many people around,
Yes.
the testimony of just a single reliable witness, even a woman, could potentially be accepted if they were deemed credible.
One witness could be enough.
In specific circumstances, yes. Oaths were also really important. Witnesses had to swear oaths, and the type of oath could vary depending on the witness's social status.
Different oaths for different people.
Yes, and the consequences for perjury, for lying under oath, were serious. Fines, definitely, and potentially severe penalties if the perjury led to a miscarriage of justice, like an innocent person being punished.
Okay.
The court also had guidelines for how to handle contradictory evidence from different witnesses, and presenting misleading evidence could obviously weaken your case significantly.
It sounds like the judges had a really significant responsibility in weighing all of this.
Huge responsibility. Judges were explicitly tasked with carefully assessing the reliability and consistency of all the evidence presented. If things were really unclear, if the evidence was truly inconclusive.
What then? Flip a coin.
No, not quite. They might actually issue a kind of middle ground judgment, or perhaps refer the matter, especially concerning disputed property, to the king. Ultimately, the stated aim was to ensure the law was applied equitably, fairly, and without bias.
A high ideal, certainly. Now, let's talk about agreements between people, the law of contract. What made a contract valid back then?
Okay, contracts. Several criteria had to be met for a contract to be considered valid and enforceable. Ideally.
A perfect contract.
The perfect contract, yes, should be made in person between parties of roughly the same social standing or community, conducted at a suitable public place and time with all the proper formalities observed, like having witnesses, and importantly, a detailed written record of the contract's specifics.
So formal and public was best.
That was the ideal, yes.
And what could make a contract invalid? What were the red flags for a judge?
Well, judges would generally declare a contract invalid if certain conditions were met. If it was concluded when one party wasn't even present, or if the thing being contracted for wasn't there.
Okay.
If it was made secretly inside a house that suggested a lack of transparency, or at night for similar reasons, or in a forest, which was considered an unusual and potentially suspect location.
Secret deals are suspicious.
Exactly. Also, obviously, contracts made with fraudulent intent or any kind of secret agreement designed to harm others. Those were out. But there were quite a few exceptions to these general rules.
Exceptions? Why?
For practical reasons, really. The system recognized reality. For example, contracts about loans or inheritance, marriage agreements, deposits of valuables, those were often considered valid even if made inside a house, because that's where family or personal business often happened.
Right. Context matters.
Exactly.
Yeah.
Marriage contracts or things done under a king's direct order might be valid even if arranged at night due to timing needs. Contracts made by people who lived in forests, their normal business might happen there. Even contracts made by, like, clandestine agents working for the state or secret associations where secrecy was kind of the point, those could be valid despite lacking some of the usual formalities. The system had some flexibility.
It had to be practical. Who wasn't allowed to make contracts at all?
Certain individuals were deemed ineligible, basically people whose judgment might be impaired or who weren't legally independent. This included dependents, like children, or maybe wives in some contexts, minors certainly, the very elderly, people who are seriously ill or in great distress.
Makes sense.
Also, anyone acting while overcome by anger or drunk or considered legally mad, or anyone acting under duress forced into it, their agreements weren't valid.
Protects the vulnerable and those not in their right mind.
Precisely. And if there happen to be multiple conflicting contracts about the same thing.
Yes. What then?
Generally, the last agreement made was considered the prevailing one, though there were exceptions to prevent people from fraudulently making later contracts to invalidate earlier legitimate ones.
Okay. What about canceling or revoking a contract? Especially for buying and selling things, or even gifts. Could you just change your mind?
The general principle guiding revocation was that neither party should suffer an unreasonable loss because someone backed out.
Fairness again?
Trying for it, yes. For sale and purchase contracts, once agreed, the terms generally had to be fulfilled unless the contract was revoked within a specific agreed-upon time, or if certain conditions arose.
Like what conditions?
Things like the goods being defective, or if there was a newly discovered risk, like the goods might be seized by authorities or stolen or destroyed, or if the goods simply failed to meet the agreed specifications, or again, if the sale was made under duress.
Okay, valid reasons.
And there was a special rule for perishable goods. Revocation was possible only with the buyer's agreement, and the seller couldn't then just turn around and sell it to someone else for a better price while the first buyer was still involved.
Interesting detail. What about gifts? Could you promise a gift and then take it back?
Promised gifts were generally treated like loans,
Meaning you had to follow through.
meaning there was an obligation to fulfill the promise, yes. However, some gifts, particularly informal promises between close family members, weren't necessarily legally recoverable if the promise wasn't kept. The law perhaps recognized the different nature of family exchanges.
Right, not everything is a legal transaction.
But a gift could be deemed invalid and thus may be recoverable or not obligatory under certain conditions.
Such as?
If it was made under duress or in extreme distress, if the person receiving the gift was considered unworthy, if the gift was intended for an evil purpose, gifts made out of anger, fear, or sorrow might also be invalid.
Motive matters.
Motive and circumstance, yes. Interestingly, inheritances weren't generally liable for things like the deceased's gambling debts or promises they might have made while drunk or infatuated.
Protects the heirs from foolish promises.
Seems like it. Even promises made in extreme distress, like promising a huge reward to a rescuer while drowning, weren't automatically legally binding. The rescuer's actual reward would be determined later by impartial experts based on the service rendered.
Sensible. What was the penalty for making an invalid contract if you did it in good faith? Just mistakenly.
Importantly, there was generally no state punishment, no fine, for simply entering into an invalid contract in good faith. The loss, if there was one, was typically just borne by the person who made the flawed agreement.
Okay, personal responsibility there. Now let's consider something really fundamental. Ownership of property. How did you prove you owned something in ancient India, especially if you didn't have a, fancy deed?
Right, title deeds weren't always a thing, especially long ago. So if formal title wasn't available, simply being in continuous, undisturbed possession of the property for a long time could actually establish ownership, prescription, essentially.
How?
Generally, 10 years of neglect by the original owner could lead to them losing ownership, although there were exceptions for people with legal incapacities, like minors or the mentally ill. For buildings, the period was longer, maybe 20 years.
So, use it or lose it, potentially.
Potentially, yes.
Mm-hmm.
But importantly, occupation by certain people like family members, tenants, or religious scholars allowed to use the property didn't automatically grant them ownership rights through possession. It had to be adverse possession.
Okay.
And there were also specific rules for dealing with property that was lost and found or stolen or captured from enemies, all designed to prevent people from unjustly acquiring ownership.
What about land and buildings, immovable property? That seems like it would cause disputes.
Oh, definitely.
Yeah.
Disputes over immovable property, like houses or fields, were often settled based on the testimony of local witnesses, neighbors, elders who knew the history of the land and boundaries.
Community knowledge was key.
Very much so. There were also restrictions on who could buy or mortgage property, sometimes based on its tax status or the social standing, or forna, of the individuals involved.
Status again.
Always. Disputes specifically about agricultural land were typically resolved by village elders, or sometimes the crown would step in and order a fair division. Again, highlighting community and state roles in resolving property issues.
What about boundary disputes, marking the edges of fields?
Boundary disputes were taken very seriously. Boundaries were marked by natural features, trees, rivers, or man-made markers. Intentionally removing or altering these markers carried severe punishment. Clear boundaries were essential for order.
And selling property. Were there rules for that?
Yes, selling property wasn't always straightforward. There could be restrictions. Often relatives, then neighbors, then creditors had a priority right to purchase the property before it could be offered to outsiders.
Right of first refusal, sort of.
Exactly. And sales usually required a public announcement or proclamation, probably to ensure transparency and prevent hidden sales that could lead to later disputes about ownership.
It sounds like they had rules for just about everything, even like blocking pathways or damaging property.
Yes, absolutely. Obstructions were categorized based on the type of land they affected. Blocking a public road was worse than blocking a minor path. Damage to public areas was punishable.
And private property.
Compensation was required for damage to private property, especially agricultural fields. But interestingly, the law showed some flexibility. Trespassing by certain groups, beggars, traders carrying goods, perhaps cattle straying, or people forced onto land by flood or fire, often wasn't considered an illegal offense, recognizing necessity or accident.
Some pragmatism there.
Seems like it. And if property was lost or stolen, there were specific procedures for reclaiming it. You had to prove ownership, report it to a designated lost property office.
A lost and found.
Essentially, yes. And the king actually had a responsibility to help recover stolen property or compensate the victim if it couldn't be recovered.
The state had a role in recovery.
A significant one, it appears.
Then what about finding treasure, buried gold? That sounds like a good way to get rich.
Well, even that was regulated. If you found a treasure trove, you were required to report it to the authorities.
Couldn't just keep it quiet.
Not legally, no. There was a system of rewards for the finder, often based on their social status. A Brahmin might get to keep it all. Others got a share. Large fines generally went to the king.
The king gets the jackpot.
Often, yes. But there was an exception. If you found treasure that you could prove was ancestral property, buried by your own family long ago, you could keep it.
Okay, that makes sense. This is all incredibly detailed. Let's move on to the, well, let's just say the less pleasant side of things.
Yeah.
Crime and how it was investigated. What were the procedures like?
Right, criminal investigation. When it came to something like burglary, the approach depended on the initial assessment. Did it look like an external break-in, an inside job, maybe a combination?
How did they figure that out?
Examining entry points, looking for signs. Suspects could include family members, servants, anyone recently arrived, or acting suspiciously. Investigators look for physical evidence, signs of distress or unusual wealth in potential suspects.
Profiling almost.
In a basic way, yes. Arrests were ideally supposed to happen promptly unless the suspect was literally caught in the act. Interrogation involved bringing in witnesses, maybe the accuser, to corroborate stories.
And torture, was that used?
Torture was considered an option, but explicitly as a last resort. And only if there was already strong evidence pointing toward guilt, and only for suspects who weren't exempt.
Who was exempt?
Generally Brahmins, minors, the elderly, pregnant women. Those with certain illnesses, they were typically exempt from torture.
Okay. What about other kinds of dishonesty, like if an artisan tried to cheat you?
Dishonesty among artisans or craftsmen was addressed through specific investigative techniques. This could include using secret agents, posing as customers, or marking materials given to the artisan to see if they swapped them for inferior ones or tried to steal some.
Undercover operations.
Pretty much, yes. Sting operations, ancient style.
And if someone died under suspicious circumstances, how was that investigated?
Death investigations involved, essentially, a post-mortem examination of the body, looking for the cause of death, signs of strangulation, poisoning, physical injury.
Basic forensics.
Very basic, yes. Investigators also considered potential motives. If the death looked suspicious, was there anger, greed, jealousy involved? People closely associated with the deceased were often questioned.
What about suicide?
Even suicide was investigated, primarily to rule out foul play to make sure it wasn't murder disguised as suicide. And there were penalties for performing funeral rites for certain suicide victims, perhaps those who died while under arrest or disgrace, suggesting a social stigma.
Okay. You mentioned torture was a last resort. Were there strict rules around its use when it was applied?
Yes, its use was supposed to be limited to cases with strong prior evidence. And as mentioned, certain groups were exempt. Even when used, the methods were intended to be somewhat proportionate to the severity of the suspected crime, though they were undoubtedly harsh.
Were there alternatives?
Yes, surveillance by undercover agents was presented as an alternative investigation method, particularly useful for those suspects who were exempt from torture, gathering information quietly.
Okay. The text also touched briefly on things like partnerships and even priests. How were legal issues handled within those groups?
Right, for business partnerships, there were established rules about how profits should be shared, what work each partner was obligated to do, and what happened if a partner got sick or wanted to leave.
What about cheating?
Embezzlement or other serious offenses by a partner could lead to penalties and expulsion from the partnership. Pretty standard business practice in a way.
And priests involved in rituals?
Similarly, for groups of priests performing rituals together, there were rules for dividing the payment or offerings received, rules for what happened if a priest got sick or died mid-ritual, and grounds for expulsion for misconduct like incompetence or maybe immoral behavior.
Internal regulation within professions.
Exactly.
And finally, just broadly on criminal investigation, what were some key principles? How did they decide who to suspect?
Well, arrest could be made on reasonable suspicion, often based on observed behaviors being found with burglary tools, having unexplained injuries after a crime, sudden unexplained wealth.
Okay.
Traders dealing in goods had a responsibility. If they were found handling stolen property, they had to prove they acquired it legally. Just possessing stolen goods wasn't automatically guilt, but you had to show you bought it legitimately.
Burden of proof on the possessor?
To some extent, yes. And throughout the whole investigative process described, there seems to be an emphasis on preventing false accusations and following a somewhat structured approach with certain safeguards built in.
Okay, so we've covered a huge amount of ground here. Labor, family, the penal system, civil suits, contracts, property, crime investigation. But what were the fundamental ethical ideas, the philosophy underpinning this whole Kautilyan legal framework?
Yeah, stepping back to the big picture. At its core, Kautilyan justice seems founded on principles like impartiality, proportionality, and this key concept of dharma.
Dharma. That's a big word. What does it encompass here?
It's complex, but here it really encompasses duty, righteousness, maintaining social and cosmic order. Just governance itself was seen as a sacred duty for the king.
A religious obligation almost.
In a sense, yes. Punishment or danda was considered absolutely essential for maintaining that order, preventing anarchy, the law of the fish where the strong devour the weak.
Right.
But crucially, it had to be applied justly, without favoritism based on status or relationship. The system itself had civil courts, dharmasya, and criminal courts, kantakashohana, with a relatively flat judicial hierarchy below the king.
And where did the actual laws come from?
Kautilya outlines four main sources of law. First is dharma, sacred law or righteousness. Second is evidence or practical affairs, vyavara. Third is custom or history, charitra. And fourth is royal edicts or commands, rodasasana.
Is there a hierarchy there? Which source wins in a conflict?
Yes, there's a hierarchy. Generally, dharma and reasoned written law, vyavahara, held significant weight, often considered superior to mere custom or even sometimes royal edicts if those edicts contradicted fundamental principles. Judges and magistrates were expected to adhere to strict ethical codes, avoid corruption, bias, delay, and face penalties themselves for misconduct.
Accountability for judges, too.
Yes. And the emphasis we saw on valid evidence, witness credibility, condemning delays or unjust dismissals, that all reinforces this ethical foundation focused on procedural fairness.
And the philosophy behind punishment itself, you mentioned proportionality.
Yes, very strong emphasis on proportionality.
Yeah.
Penalties escalating for repeat offenses, yes, but also needing to consider the intent behind the crime, the circumstances, the offender's capacity. It wasn't just about the act, but the context.
Nuance in sentencing.
Exactly. And remember, rewards were also part of it, recognizing and rewarding good conduct, especially by officials. Fines were meant to be carefully calibrated. Even capital punishment, while available for heinous crimes, often seems to have had alternatives considered.
And those unusual punishments, like branding for Brahmins.
Those serve more symbolic or social purposes, shaming, marking, removing from status, rather than just pure physical retribution.
Yeah.
Crime prevention was also key, using intelligence gathering, undercover agents, requiring doctors to report suspicious injuries, protocols for handling dead bodies, all aimed at preventing crime or catching culprits quickly.
Proactive measures.
Yes. And finally, the system wasn't totally rigid. It incorporated flexibility. We saw leniency for vulnerable groups. There was room for ritual penance, for religious recluses, for minor offenses, though serious crimes like theft or violence still brought standard punishments even for them.
It sounds like a remarkably comprehensive and in some ways surprisingly nuanced system for its time. Thinking about it now, what can we maybe take away from this in a modern context? Are there lessons here?
I think there are several potential takeaways or points for reflection. The Kautilyan model's emphasis on the rule of law as foundational is timeless. The focus on judicial ethics and accountability remains critical everywhere.
Right.
The way it recognized custom alongside formal law offers insights into legal pluralism. You could even see elements resembling restorative justice in some dispute resolutions or compensations. And certainly, the strategic use of intelligence for crime prevention has echoes, for better or worse, in modern policing.
But it also highlights challenges we still face, right?
Absolutely. It underscores the ongoing struggle to ensure efficient court processes, to maintain transparent and meritocratic judicial appointments, to effectively incorporate community perspectives and customs into formal jurisprudence, and crucially, to uphold the highest ethical standards in law enforcement and the administration of justice. The ideals were there, but living up to them is the perpetual challenge.
Well, this has been an absolutely incredible deep dive, seriously fascinating look into a complex legal and social system. It's just amazing how much detail and nuance existed back then in ancient India.
It really is. It definitely challenges many common, perhaps simplistic assumptions about ancient societies. It reveals these really sophisticated approaches to regulating almost everything: economic activity, family life, crime, justice administration.
Yeah, truly sophisticated. So as you think about all this, our final thought for you, the listener, is this. How do these ancient principles of justice, of social order, how do they resonate or maybe clash with our own contemporary values and legal frameworks today?
That's the question.
What aspects of this ancient system might still hold some relevance, maybe surprisingly? And what does studying it tell us about the ongoing, maybe universal quest to create a just and well-ordered society?
Lots to think about there.
Definitely. We really encourage you to explore further into ancient Indian history and legal thought if this sparked your interest. Thanks so much for joining us on this deep dive.